Welcome to this presentation on writing effective SQE1 single best answer multiple choice questions. The SRA hosted a summit in October 2024 to discuss the University of Exeter's research into the potential causes of differential outcomes in legal professional assessments. An output of the summit was the development of an action plan involving a variety of stakeholders. One of the actions focused on what can be done to help candidates prepare more effectively for the SQE assessments. The purpose of this presentation is to provide some guidance to anyone who is involved in producing candidate preparation materials for SQE1, specifically single best answer multiple choice questions. The aim of the workshop is to help align SQE1 preparation multiple choice questions with the multiple choice questions candidates face in the SQE1 assessments, and therefore improve the effectiveness of preparation for SQE candidates. This presentation will look at the following: why and where multiple choice questions are used in high-stakes professional assessments, the importance of having a question writing process, the use of assessment data to inform question writing, the level at which the questions are set in SQE1, what single best answer multiple choice questions are, and the component parts of a single best answer multiple choice question, including some guidance on best practice when drafting these questions. Turning first to the use of multiple choice questions in high-stakes professional assessment. Multiple choice questions are commonly used in professional assessments and have proven to be an effective method of assessing the application of knowledge. Multiple choice questions are used to assess the application of knowledge in many high-stakes professional assessments across professions and jurisdictions. Examples include the assessments for entry into the medical profession in the UK and assessments testing applied knowledge in the accountancy and financial professions. Multiple choice questions are also used in other legal professional assessments, such as the Bar Standards Board's centralised assessments in England and Wales, the National Conference of Bar Examiners multi-state bar exam, as well as the planned next-gen bar exam, both in the US, along with other jurisdictions such as India, Brazil, and Canada. In a high-stakes professional assessment, there are a number of reasons why multiple choice questions are used when assessing the application of knowledge. These include standardized scoring. Having a single correct answer eliminates any potential for bias or subjectivity in marking. The quick and accurate marking of large numbers of candidates, allowing for an effective sampling of a curriculum, ensuring an understanding across a range of subject areas rather than a few selected topics. Well-designed multiple-choice questions can assess higher-order thinking skills such as application, analysis, interpretation, problem-solving, and evaluation. Multiple-choice questions allow for a relatively large number of questions to be used which, along with randomized ordering, helps with test security. They remove the requirement for written expression, which is not required for a test of applied knowledge. They provide a large amount of data to help with the quality assurance of an assessment. And finally, their use has been proven to provide highly reliable assessments with questions that discriminate well between candidates of differing ability. Having a question writing process involving expertise in both the relevant subject matter of the questions and question writing more generally is important in being able to draft good quality multiple choice questions. This is an overview of the process involved in producing SQE1 questions. All questions in SQE1 are drafted by a solicitor who has expertise in the relevant subject. The questions are second reviewed by at least one, often two, further solicitor subject matter experts who undertake a check for legal correctness, and that the questions are pitched at the level of a day one newly qualified solicitor. Two further reviews are undertaken by non-subject matter experts. These checks are looking at sound question writing principles, which will be discussed shortly. Non-subject expert reviews are also useful to check for anything which may unintentionally mislead or confuse a candidate. A sample of the SQE1 questions that enter the SQE1 question bank are also reviewed by the SRA's solicitor subject matter experts who undertake checks for, amongst other things, legal correctness and appropriate level. The SQE1 questions are then subject to a number of further review processes, including after each assessment, alongside the relevant question performance data, on an annual basis, and also following any change in the law that might impact a particular question. One of the advantages of multiple choice questions is that they produce a lot of performance data that helps assure both the quality of the questions and the assessment, as well as provide useful information to help improve question writing. Some of the data sets that are analyzed in relation to the SQE1 assessments and individual questions are set out. This data can help assure the assessment is fair, reliable, and consistent. It also provides information on how the candidates perform on the questions in terms of their level of difficulty, how long they take to answer, if they are discriminating appropriately between candidates of differing ability, and if the distractor, or incorrect, options are functioning well. Differential item functioning provides a check for any differences in performance on a particular question by candidates of the same ability, by characteristics such as ethnicity and sex, to help to assure the assessment questions are free from bias. An important part in writing an SQE1 question is ensuring it is written at the correct level. The SQE1 assessment specification sets out that the questions should cover core legal principles and rules and be set at the level of a competent newly qualified solicitor. SQE1 questions are not designed to test matters of detail which a newly qualified solicitor would be expected to look up. The SRA's statement of solicitor competence, supplemented by the threshold standard, in particular Level 3, is a good starting point when considering the standard or level of a newly qualified solicitor. The level of a newly qualified solicitor can also be established by using various other sources and experiences, including question writers and reviewers having their own experience as a qualified solicitor. Using freelance question writers who are currently in, or have been in, practice to help write or review the questions is also helpful, as is a review undertaken by external qualified solicitors. Having membership of various professional bodies can also help maintain links to the profession, as can other activities such as court visits, conferences, and training events. Prior legal educational experience can also be helpful. The type of questions used in SQE1 are single best answer multiple choice questions. Single best answer multiple choice questions require a candidate to select the single, most accurate option based on the fact pattern or scenario, referred to as the STEM, and the specific question being asked, known as the lead-in. Single best answer questions should make it clear that only one option is to be selected. With single best answer multiple choice questions, the incorrect options should be plausible. They can be partially or wholly incorrect and can be based on common misconceptions. Now to look at the component parts of a single best answer multiple choice question. This is one of the SQE1 sample questions taken from the SRA SQE website at the point of publication of this presentation. The law may have changed since publication of this presentation, but its purpose is to illustrate the component parts of a single best answer multiple choice question. The first few paragraphs set the scene. It gives the candidates the fact pattern, or background, and provides the context in which the question will be asked. This part of the question is described as the STEM. Then we have the question itself, which is in bold. This is called the lead-in. Finally, you will see there are 5 options, or answers, marked A to E. Only one of the options will correctly answer the lead-in. The incorrect options are known as distractors. Now this presentation will look at each of the STEM, the lead-in, and the options in turn, explaining the general approach to each of these component parts of a question. Please note that these are general principles only, and whilst it is important to follow them as much as possible, you may find it necessary to depart from some of them depending on the context of a particular question or area of the FLK. An example relating to the lead-in and the cover test will illustrate this point later. Some key points relating to the STEM. Firstly, it is important to have a sufficiently detailed STEM. SQE1 involves the application of legal knowledge to a particular scenario, not simply surface knowledge or recall, so it is important that every question is set in a particular context to which candidates can apply their legal knowledge. All information necessary to support the options should be included in the STEM, with no new information being provided in the options. Essentially, all the information which the candidate will need to analyze both the correct answer and the incorrect distractors should be contained within the STEM. If certain distractors are not supported in the STEM, they can be more easily ruled out by candidates. As explained earlier, it is important that the options are all plausible. Irrelevant detail or background should be avoided. Each question has to have sufficient information to support all of the options, but having regard to the time available to candidates during an assessment, the STEM should contain nothing more than is needed. Question writers should consider this when first writing questions, but this is also something you should consider during the editing process. Superfluous information should be removed. The question should pass the Who Cares test. Questions should be realistic and based upon scenarios that a newly qualified solicitor might encounter in practice. The questions should avoid stereotyping and bias. Whilst there are different approaches that can be taken, SQE1 questions use general descriptors for characters, such as the man, the woman, and a solicitor, rather than actual names. It is worth referring to the SQE1 sample questions, where you will see that the SQE1 questions do not use proper nouns. This is simply to try to make it easier for candidates to navigate the question. For example, using a character such as the woman allows for that character to be easily referred to as her or she later on in the question. Also, certain names may not be familiar to all candidates. As part of the editing and review process, it is important to ensure that the bank of questions has an appropriate balance of characters. As mentioned earlier, it is important to avoid irrelevant detail or background, and so questions should only use the minimum number of characters required for the question to be effective. Questions should use clear standard English, being mindful that a number of the candidates may not have English as a first language. Questions should be carefully reviewed to ensure that they are not using any colloquialisms or difficult language that may not be easily understood by those candidates. However, depending on the subject area, it may be necessary to use certain legal terminology. Questions should also avoid sensitive or sensational topics if possible. It is also important to consider the word count of the questions. There are no hard and fast rules as to what an appropriate word count might be for a particular question. They will inevitably vary in length. However, it is important to avoid irrelevant detail or background, and to ensure that candidates have enough time to read and comprehend the questions. The data referred to earlier relating to candidate response times and the proportion of candidates that answer a question correctly can provide assurances in this regard. We are now going to move on to the lead-in, which is the specific question that candidates are asked to answer. The lead-in should be as focused as possible and should ensure that the candidate is clear that there is one correct answer, and so only one option is to be selected. Ideally, candidates should only be asked to deal with one specific task. The lead-in should avoid asking candidates to do more than that. For example, a question that asks candidates to identify firstly what board and shareholder resolutions might be required to approve a particular corporate action, and then secondly, what disclosures should be made, and what then needs to be filed at Companies House, would not be a question that asks candidates to focus on just one task. Negative lead-ins should be avoided. This simply means that candidates should not be asked a question that is framed in a negative way. For example, what should the man not do, or which of the following is not an incorrect statement? Research has shown that negative questions are much harder for candidates to tackle. If you find yourself with a question with a negative lead-in, consider how the question can be reframed to avoid it. And finally, the cover test. Ideally, questions should be able to pass the cover test. That is, once a candidate has read both the stem and lead-in, they should already be able to predict what the correct answer might be. This means that if the candidate covered up all of the options after having read the stem and the lead-in, they could likely predict what the correct answer might be before going on to read each of the options. Equally, candidates should not be able to arrive at the correct option without having read the stem. It is not always possible for questions to pass the cover test, but questions should aim to do so where possible. Where it is not possible, careful consideration needs to be given in the drafting of the question to ensure candidates are able to identify the correct option and have some idea what they are looking for before reaching the options. There are a few good examples of lead-ins shown in pale yellow. Of course, there are many different ways of drafting a lead-in, so these are just examples, but they are all focused and relate to one specific task. Contrast these with those shown in pale pink, which are examples of the types of lead-ins that should be avoided as they, from left to right, refer to more than one task, are negative in nature, appear to test only knowledge recall, or fail the cover test. It is not always possible to draft a lead-in that passes the cover test. For example, it is not uncommon to see a lead-in that starts with the phrase, "Which of the following best describes?" Whilst this may not be as focused as it might be and fails the cover test, it can be an effective form of lead-in, used in situations where the incorrect options are very plausible or partially correct, but where the correct answer is superior. This can reflect real-world decision-making, whereby solicitors are often tasked with choosing the best course of action from a group of viable options. Finally, turning to the options, there are a few things that the options should do. looking at each in turn. Firstly, and most importantly, there should only be one correct answer. All other options we describe as distractors. They should all be plausible, and all should be likely to be selected by some candidates. Question performance data can be reviewed each time a question is used in an assessment to help assess whether options are plausible. Having plausible options is important to ensure that the questions discriminate properly between candidates of differing ability, and makes it more challenging for candidates to simply guess and answer correctly, without having the required knowledge. How can a distractor be plausible? Distractors can draw on faulty reasoning, common misconceptions that question writers have encountered amongst practitioners or law students, or a distractor can be only partially correct, based on the wording of the lead-in. All relevant information that candidates will need to evaluate the correct option, and the distractors must be contained in the stem. New information should not be introduced to the options. By doing so, candidates may feel the need to refer back to the stem to check they had not missed any information. All options should answer the specific question being asked in the lead-in. If they don't, they can be easily ruled out by candidates without applying any knowledge. The precise wording or phrasing is important here. For example, a lead-in that asks, "What searches should the solicitor undertake?" should not then have an option that starts solely with the word no. The word no does not answer the question being asked, and as an additional point, the lead-in appears to be looking for a positive answer. In that scenario, the option should be amended, for example to begin with the word none or no searches, and the lead-in should be amended to include the words if any. So it reads, "What searches, if any, should the solicitor undertake?" All options should ideally be of a fairly consistent length and be drafted in parallel language, so that there isn't one or more particular option or options that stand out from the rest which candidates can easily dismiss as wrong, or alternatively can easily determine to be the right answer. It can, however, be difficult to have 5 options that all look the same as each other. So, for example, a question could have 3 parallel options and another 2 options that are parallel to each other. The key is to ensure that the candidate cannot determine the correct answer just by looking for clues in the drafting. Try to avoid having any conditionality in the options that then may introduce new information. Often using the words if or unless can do this. As set out earlier, the information candidates are required to evaluate to analyze each of the options should be contained within the stem only. In a similar vein, try to avoid adding new facts to a question in the options. Try to keep the options as short and simple as possible. Overly lengthy options can lead to candidates being unable to read the contents in the time allowed and being forced to guess. Candidates may not have English as a first language, so, as with the stem, keep the language simple, appreciating the need to use certain legal terminology. Avoid options which overlap with each other, which would enable candidates to eliminate both options, or options which might provide clues to candidates to determine the correct one. Try to avoid absolute terms, such as always or never. The use of these sorts of terms is likely to assist candidates in eliminating a distractor. There may be a different way to express the option. Equally, avoid using vague terms such as seldom or often, as these can also have a similar effect. We hope that this has been helpful. By way of some final thoughts, well-drafted single best answer multiple choice questions can be an effective method of assessing the application of knowledge. It is important to understand what you are testing and at what level. A thorough question writing process is important, having the correct level of expertise in both the relevant subject area and also in question writing itself. Where possible, use data to inform the effectiveness of question writing and as a tool for question improvement.